The content of this video, as well as the thoughts, views, and opinions expressed herein, belong to the presenter and do not necessarily reflect the views of Brigham Young University or the Church of Jesus Christ of Latter-day Saints.
Welcome. My name is Rob Bolick. I'm an attorney. Spent my years practicing in Utah and Nevada and Utah. So today we're going to talk about domestic asset protection trusts. This is the fourth in the set of seminars that I've done. This is my favorite. Hopefully we can have a lot of fun and learn some good things. So today, again, Utah versus Nevada versus Wyoming. So we'll start out with, what is an asset protection trust? Okay, how do they work? Who can use them? Comparison of the three different jurisdictions, typical structure. And the nice point is you don't have to be a resident of one of these three states in order to have them. I've just chosen these three. These are the ones, continental U.S., west of the Mississippi. So these are the three choices. Other jurisdictions that are good, Alaska has a good one, South Dakota, Delaware, there are some other ones, but just focusing here on the West. Okay, so to start out with, what is an asset protection trust? Essentially, it's a trust which lets you be the trustee and the beneficiary. Actually, this is unique to Nevada, but we'll keep going on this. So you can maintain 100% control, use, and benefit of the assets throughout your life. And essentially, the bad guys don't have access to your assets after 2 years. So this sounds too good to be true. What's the catch? There is a 2-year waiting period. So rules are you have to create the trust, transfer the assets into the trust, and then 2 years later, a lawsuit is filed, and then you're good. So it's not, the nice thing is it's not when the liability occurs, but it's when the lawsuit is filed. So that goes in your favor. So 2-year term begins again, not when the trust is created, but when assets are put in. So it's on an asset by asset basis. So I set up my trust. Again, I'm the trustee, I'm the beneficiary, and I create the trust. Day 1, day 2, 3, 4, whatever, I start putting assets in. It's on an asset by asset basis on Tuesday, Wednesday, Thursday, whenever the asset goes in. So the strategy, of course, is create the trust and put the assets in as soon as you can. Okay. So the 2-year 2-year period works for everything except for personal service income. That is, I as an individual get W-2, 1099 income. I then put it into the trust. That's a new contribution. So everything else, I can put my house in, savings accounts, other things, and those things are effective the day it goes in. So those are the rules. The nice thing here is the 2-year period, it ends not when something bad happens, but when a complaint is filed, complaint being a lawsuit. So here's an example. You set up the trust, you put the assets in, 18 months later, you're in a car wreck. Typically in a car situation, you have a 1-year statute of limitations before you file a complaint. Most plaintiff's attorneys will try to maximize the damages. Physical therapy, meds, medical, whatever, psychological, blah, 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 whatever they can do to maximize the claims that they will have. And so a lawsuit is filed before the 1-year statute of limitations expires. And so 12 months later, a lawsuit is filed. Are you protected? The answer, of course, is yes. Why is that? If your math is good, 30 months is more than 24. So 1.5 years into it, the liability occurs. Lawsuit filed 1 year later. That's 6 months beyond the date of that they had to file. So good to go. So in actual, or in real life, how it works out is instead of a 2-year period, it's a little bit less. So that goes to your favor. So basically the point is you can take steps now, create an asset protection trust, transfer the assets in, and then in 2 years, you're protected for the rest of your life, okay? How did this come about? Background, let's start with this. This is a phenomenon of small states only, okay? Small states being population, not geography. So, as my brother-in-law who lives in Alaska likes to tell me, if they cut Alaska in two, Texas would be the third biggest state. So, a lot of territory there. So, started in Alaska and Delaware, 97. Nevada 99, South Dakota 2005, and then after that a lot of other states have jumped on the bandwagon, including, again, Utah and Wyoming. So what is the purpose of this? Essentially, it's to approximate offshore trusts. So let's go back to Delaware. So you were back in the 90s somewhere, you live in Delaware, whether you're a DuPont or somebody else, you have a bunch of money and you're afraid, if I get sued here in the U.S., somebody's going to get it. So what am I going to do? Well, obviously, I'm going to go down to the Cayman Islands, set up a trust, put my money down there. I get sued in the U.S. Nobody can get whatever my nest egg is down in the Cayman Islands. Again, let's go back 30 years some ago, and that's the way the game was played. So the light goes on, Delaware. Oh my gosh, we're missing a business opportunity. We'd much rather have the assets here in US of A than have them be sitting in some bank account on a sandy beach island somewhere. And so the legislatures got together and said, we want to approximate what you can get by going offshore by keeping your assets here. So the purpose was to allow assets to be held here, US of A. The other nice thing about a domestic trust as opposed to an offshore one is you can be the trustee, as opposed to paying a bank down in a foreign jurisdiction to have exclusive control of your assets. So you pay somebody to lose control of your assets. That's not good. If that's the price you got to pay in order to get asset protection, it's better than losing it. But yay for the states that have decided to do something domestically. So essentially you get more control, and it's also less expensive. Going offshore is going to cost typically $20,000, $25,000 upwards from there. The foreign trustees are going to be $3,500 to $5,000 to $7,000 a year. And so your domestic trust, typically they run in about the $5,000 plus price range. So it is very expensive, but it's not as expensive as doing something else. And if that's the price you need to pay to protect yourself, it might be money well spent. So public policy exclusion period is that initial 2-year period. There's a reason for that. And what is it? It's public policy consideration. So what the government doesn't want is for you to dodge legitimate claims of a legitimate creditor, plaintiff. Okay, so you can't get incur liability, run out quickly, set up the trust, put your assets in, and then you're safe. Bad public policy. So what they did say, though, is that we're going to let you protect yourself against the unknown, unforeseen. So the purpose of the 2 years is to protect existing creditors. You're not going to cut them off. Initially in Alaska and Delaware, they had a 4-year statute of limitations. When Nevada adopted this statute in 99, whacked it in 2. So it became a 2-year statute, and that was the model that all of the other states have followed since, including Utah and Wyoming. Okay. So that's the basics. Question: will a revocable trust, living trust, family trust give you asset protection during your life? If you had listened to any of the prior presentations, the answer is no, it doesn't. That's a common misconception of people. Well, I have a trust set up. I have a living trust. I went to the attorney, paid a bunch of money, got this all set up. What that does is it avoids probate, the state proceeding of what happens when you die to get from you to your heirs. So living trust, excellent asset protection, excellent estate planning vehicle. Again, the trust acts as the will substitute, but it avoids probate. So wonderful for estate planning, 0 for asset protection. So I ask people on a scale of 1 to 100, where does your living trust come in on for asset protection? The answer is it doesn't. It's 0. So what happens is a lot of people think I've got the trust, I'm invisible, I'm bulletproof, and 0 for 2. So again, just the illustration here. So again, Mary, of course, perfect little angel, never do anything wrong. John, pretty close to an angel, but something happened. So something happens, John gets sued, bad guys win. They can pierce through the veil of a living trust. The living trust is considered for legal purposes as if it didn't exist. So anybody can get in at any time. Contrast this with an asset protection trust. So just so you can understand what are the illustrations here, did this kind of as a double line. So with the asset protection trust, this is an irrevocable trust. We're going to go over the provisions of the requirements to set up a trust. All of the asset protection trusts are purely a creature of statute. So the states that have them, they have specific statutes that say, you follow these rules, now you can have a domestic asset protection trust. And so, as we're going to talk about as we go forward, the irrevocable part doesn't restrict John and Mary in any way. It doesn't need to. All the irrevocable part does is provide the barrier to make it a distinct entity. It's different than them, and that's what gives you asset protection. So irrevocable is good. It's not bad, but let us continue. So again, something happens to John. He gets sued. They put the assets in the trust. So for the first 2 years, the asset protection trust provides no more protection than your standard living trust. Good news is after 2 years, nobody can get in ever under any circumstances. So yay. All right, trust terminology. You have the trustor, grantor, settler, all different words for the same thing, namely the person who creates the trust, namely you. The trustee is the person who holds the assets in the trust, also you. Beneficiary is who the trustee is holding the assets for the benefit of. That also happens to be you. You don't have to be schizophrenic. You can have all three roles, no problem. Lastly, what I like to do in all of these is to set them up as grantor trusts, meaning they are invisible for IRS purposes. So with a grantor trust, for tax purposes, it is treated as the alter ego of you. For the ownership of the assets, it absolutely isn't. It's a separate independent entity. Okay. So tax consequences. Are there any tax consequences of contributing assets into a trust? And the answer is no, assuming it's a grantor trust, how you'd want to set it up. Why is that? Again, it's treated as a flow-through entity for IRS. Okay, so what is the effect of having your asset protection trust be a grantor trust? The good thing is you don't have to file a tax return. So tax return for a human, 1040, trust, 1041, trust or estate. And so no 1041 needs to be filed for the trust. All of the income, profits, losses flows through the trust, is reported on John and Mary's 1040, the same as if the trust didn't exist. So again, the purpose on these trusts, the asset protection trust or living trust, is not a tax dodge. It's not meant to give you certain tax benefits. It's simply pure and simple asset protection for the asset protection trust, pure and simple estate planning for the living trust. Okay, so want to compare the different jurisdictions here. So actually, it's easiest to start with Wyoming. Again, like I had mentioned in our last seminar, Wyoming is where LLCs were invented. They're cutting edge in crypto and a lot of things. LLCs, good. Trusts, I don't know what the legislature was thinking, but they put a provision in there that says this trust will work for asset protection unless a judge says it doesn't. So typically that doesn't give people a lot of, security there. Again, so because of that unknown that's still out there, typically don't recommend Wyoming trusts. So your next two candidates are Nevada, Utah. As you can see from here, by the time we finish this, Nevada is really superior to Utah in a lot of ways. Basically, Nevada's ranked #1 in the nation, Utah way down there, but let's show you why. You don't have to take my word for it. So first point is settlers can serve as the sole trustees of the trust. Nevada, yes. Utah, no. Typically, that's enough to check off the box before the another point is settlers can distribute assets to themselves without the consent of an adverse party. I'll explain about that. Now, the UCA, that is the Utah Code Annotated. I worked at the reference library when I was law school at BYU, and would have people come in. I want the Utah Code anointed. It's like, well, you're mixing church and state. We do have some that are anointed in our state, but the statutes aren't one of them. So Utah Code Annotated, have the reference there at the top. The Nevada Revised Statutes is Chapter 166. Utah Code is 25-6-14, and then the subsection there is where that comes in. So, again, Nevada, settlers can serve as their sole trustees, yes, okay. Usually that's enough for everybody. Just also going to the bottom line, frankly, as an attorney, I have never done a Utah trust for a Utah resident because the Nevada trusts are so much easier, so much stronger, better, more user-friendly, but let's keep going. So number 2 there, settlers can distribute assets to themselves without the consent of an adverse party. Nevada, yes. Utah, no. Adverse party, that sounds a little bad, but it's not as bad as you think. Under the Internal Revenue Code and the statutes, adverse party means somebody who would be adversely affected by it. And so typically, if your trust says this is for my wife and I as long as we're alive, then we're gone, it goes down to the kids. Basically, the kids in this case would be the adverse party. I'm not talking about just teenagers, okay? I'm talking about somebody who would be negatively affected. So the extent is if I am in Utah and I set up a Utah trust and took money out, that's good for me, but the kids would be adversely affected. So under Utah law, you have to have the consent of an adverse party in order to have it come out. Okay. Here's another thing. Under Utah law, you're not allowed to modify the trust without the consent of an adverse party. So it is kind of, cast in concrete. Nevada statute's much more flexible. Essentially, under the Nevada laws, you can change assets whenever you want. You can change trustees whenever you want. You can change beneficiaries whenever you want. So there's nothing that you are giving up by putting it in an irrevocable structure. The only thing you're doing with that is it's one of the statutory requirements under all the jurisdictions to make it different than you and provide asset protection. Okay. Next one, trust principal can be distributed to you, the settlor creator, for any reason or for no reason without an express provision in the trust. So yes in Nevada, no Utah. All right, let's keep going. Settlers can veto any distribution. Well, yes, so that's good. Typically under the Nevada trusts, you are the trustee and you don't have to veto yourself, but in Utah, if you have somebody else as a trustee and they were going to make a distribution, you have the right to stop that, okay? Here's another one. This is another thing that's a bit annoying under the Utah law is every time you put something into the trust, you have to do an affidavit of solvency. So you have to go back to the attorney, whoever helped you set this up, have to do an affidavit sworn to, attested under penalty of perjury. Every time you put something in, you have to execute this affidavit, but it gets even worse. You have to publish it in the newspaper. So with the exact value of whatever you've done, of financial accounts, that's easy. Real estate, not so much. So every time I put something in the trust, I have to tell the world about it. I put it in, and here's how much it's valued, and you know exactly what I'm doing. And it's not as user-friendly as ignoring all of that. Okay. So now switching to, again, these sections are now under the Nevada statutes. There is a statutory presumption that distributions are made from the last money in. In other words, this is called a LIFO under accounting, last in, first out. So under the Nevada statutes, if you're not really good at keeping track of your money, you put some in 6 months later, you put some in 12 months later. if you haven't segregated, if you haven't kept track of where the money is, the statutory presumption is that whenever you take something out, it is from the last money that goes in, of course, to protect those that have been in there the longest. So it's a nice provision. Here's another one. So you own your home, you're going to refinance. Probably not today. What, a few years ago that would have been better, but interest rates currently are dropping. Nice. So lenders don't like to lend on money in an entity, not a corporation, not an LLC, not a trust, okay? They don't want to have to read the documents, decide whether you have the power to do it, what are the limitations. Here's a 30-page document. We'll send it to our legal department. We'll get back to you in a month or two, okay? Lenders don't like to lend money, lend on property held in an entity. They like to lend to humans. So the drill is, I put my house into my trust, whether living trust or asset protection trust. I want to refinance. I want to get a second mortgage. I want to do something. Lenders are going to make you take it out of the trust, put the lien on, get the loan, and then put it back into the trust. So one of the questions under Nevada law was the putting it back in. Does that constitute a new contribution and start the 2-year clock over, or does it relate back to the time that the original property went in? Fortunately, NRS 166-174 says, no, we're going to treat it as if the original contribution is the date that we look at. So the fact that you took it out, got a loan on, put it back, we're not going to jeopardize, we're not going to penalize you for doing that. It works. So yay. So there's no problem with a party under Nevada law of being basically a subordinate party. So marriage, family, whatever. The Nevada statute specifically states, again, that you don't need to be an independent party. So typically you can have your kids, you can have your whoever, parents, siblings, whoever you trust the most, you can put them in as fiduciaries, and there's no pretext of having an independent, get a bank or somebody to be your trustee. Okay, another nice thing under Nevada law is the plaintiff has to bear the burden of proof to establish that it was done by clear and convincing evidence that you committed a fraud. Fraud is a very high standard. That's a hard one to prove, and the burden is on the plaintiff to say that it was a fraudulent thing. So one of the nice things here is that essentially if you have some family members or other things, they say, oh, Rob, I'd love to help you out. I just don't want to be liable for it. And so the trustees are not liable absent some willful act of malfeasance sometime. So that's kind of just looking at Utah, Nevada. Again, Nevada is much more user-friendly. Namely, you don't need a third party. You don't have to pay an independent third party a bunch of money to have control of your assets and veto any distributions. Actually, Utah did improve the statute going back a while. You couldn't even be a co-trustee. Now you can be a co-trustee. Used to be when you had your independent trustee, you weren't allowed to even talk to them about investments, no under-the-table agreements. You can't suggest distributions. It was completely 100% at the sole discretion of the third party. Not really good. Okay, Utah amended the statute to say, yes, you're allowed to talk to this person now. So you can talk to them, but you still have a third party, whereas under Nevada, you can just do it on your own. Okay, so again, some of the advantages in Nevada, you can be your sole trustee, you have sole discretion over distributions, change trustees without any, whenever you want to. Assets don't have to be held in Nevada. They can be held anywhere in the world. You don't have to go through this executing affidavit of solvency and publish notice every time you put something in. Not required. And all of your other trustees are protected by statute for anything other than a knowing act in bad faith. Okay. Statutory requirements. Trust has to be irrevocable. Again, that's not a bad thing. That's what makes this a separate entity, not you. It's independent of you. Good thing, not a bad thing. Again, it doesn't restrict your access to any of the assets, okay? Nor does it limit your ability to take things out of the trust or designate who the beneficiaries are. Again, the irrevocable part is what gives you asset protection. So that's the first requirement. Second one is, again, it's how you create it, is what they call a spendthrift provision. What this does is it says that no creditors of yours can ever attach any assets in the trust. So one of the old things going back, historically is, I'm the beneficiary of this trust. I can't take things out, but if I can pledge it as collateral, I can borrow money against it, in essence, do the backdoor thing. And again, that's what they call the spendthrift provisions prevent that. So nobody can compel you to make a distribution. All the assets are safe from anybody. Again, no F word, which of course would be fraud. You can't have any intent to hinder, delay, or defraud creditors. So can't be any bad action there. Hopefully the 2-year rule, takes care of that. But even if you could run, hide, whatever, if it were a way to, if you're trying to defraud an existing legitimate creditor, cannot happen. Lastly, in order to get jurisdiction, this would be for all of the states, is you need one of the trustees. The two requirements are: one, assets in Nevada or a Nevada trustee. That's what gives Nevada jurisdiction to allow you to basically import Nevada laws. So we set these up. I'll explain about this more later, with 3 levels of trustees. Typically what we do is we have the one that has jurisdiction is in the bottom slot with the bare minimum touches of what you need to give you jurisdiction. Essentially, those in the top slot, what we call investment trustees, that's you. 100% control over all distributions, investments, buy, sell, trade. We put in a firewall. Number 2, distribution trustee. Typically, this is it's somebody who's got your back. And again, under Nevada statutes, it can be family member, child, parent, sibling, business partner, whomever. So you have that. And then lastly, you have, the Nevada trustee, basically a placeholder to give you jurisdiction. Requirements are something above a few brain waves, a pulse, and a Nevada address. It's a little higher than that, but it's not a big standard. Okay. Typical structure. Investment trustee is you. Again, you're the person who creates the trust. Number 2, distribution trustee. Again, whoever you trust explicitly, tier number 2. Tier number 3, what they call a trust protector or trust consultant, is, again, trusted party number 2. Okay. So what does this look like? Investment trustee, again, is you. So you have 100% exclusive control over all of the assets in the trust. Buy, sell, trade. You don't have to get anybody's consent, permission, input on anything. You're in control. Okay. Distribution trustee, tier number 2, typically that's somebody else you trust a lot can fill that slot. Typically, if you have a responsible family, you can do that. If you're out of people you trust, and some minority of clients are in that, well, get an independent trustee to fill that role. Their job is to have your back. So they can't. The way we give this teeth, to work is we say that before you make a distribution, this distribution trustee has to approve. So it doesn't have to be in writing, doesn't have to be in advance. So, for example, in my trust, I have my oldest son as my number 2 trustee. I know, I can tell him, Robbie, the right answer is yes, or the right answer is no. And, he can then, basically, he's not an impediment. Don't even have him there. It is to make my life miserable. I basically do things whenever I want, however I want, as often as I want. And if he ever needs to answer, he knows the right answer to give. But typically, it's never going to arise a situation where we need his input. Lastly, again, tier number 3 trustee, trust protector, trust consultant. It's somebody that you trust a whole lot. Now, how we have this work is, again, you in slot number 1 have exclusive control over everything within the trust. Let's say you fall out of love with whoever you have in tier number 2. 1 plus 3 can replace 2 at any time. You fall out of love with whoever you have in tier number 3. 1 plus 2 can replace 3 at any time. Neither 2 nor 3 have any access to any assets, any say in anything, cannot affect your life in any way. They're there to help you, not to make your life miserable. So we have enough structure there to have the thing work. Let me do a little tangent here about why you would want this. There was a case in Nevada, the Anderson case. Mr. and Mrs. Anderson were bad people, okay? They did a Ponzi scheme, ill-gotten gains, $5+ million that they got. FTC comes in years later. Government doesn't work lightning fast. So Andersons get sued. FTC gets a judgment for 5 point whatever million. So in one of the things judgment creditors can do is haul you into court, make you answer under oath, penalty of perjury. Where did the money go? Okay. And so bring them in. Mr. and Mrs. Anderson, you owe us 5 point whatever million dollars. Yes, we do. Can you please write us a check? Well, we don't have any money. We can't do that. But you did. Oh, yes, we did. Well, where did it go? Well, we set up a trust in the Cook Islands. We have a bank there as the trustee, and all of our money is down there. I said, okay, well, could you please contact the trustee, have them send the money to you so that you can give it to us? Sure, we're happy to do that. Trustee, wired, didn't call. Please send us the money so we can give it to the FTC. Trustee says, not going to happen. Okay, this would be a breach of our fiduciary duty. We are not allowed to give assets to anybody if it's going to go to an adverse party, and we know what's happening here, and so the answer is no. Okay, wasn't the answer the FTC was looking for. So they went to the judge and said, these guys are pond scum. I don't know if that was a finding of fact or what they were able to do, but the judge agreed, yes, you truly are pond scum, and that would be my opinion as well. Cheat these little old ladies out of their life savings, whatever they did in the Ponzi scheme. Okay, so the judge says, all right, Mr. and Mrs. Anderson, we're going to raise the stakes here. We're going to have you go sit in jail. I'm going to hold you in contempt of court because you have not produced the assets. And so go sit in jail and see if you can come to reason. So Mr. and Mrs. Anderson go to jail. So FTC says, please wire the trustee, have him send the money so you can get out of jail. So Andersons wire the trustee, please send us the money that we can give to the FTC so we can get out of jail. Trustee, of course, says, not going to happen. That would be a breach of our fiduciary duty. If we did that, we'd be liable to you for damages because under our agreement, we can't do this. So now again, this gets into some of the legal niceties here. One of the defenses to a contempt action is impossibility. So the classic example they tell you in law school is the judge orders you to produce a pound of moon rock. And so you can go in there and say, I'm sorry, it's impossible. I can't go to the moon. I don't have access to any moon rocks. And so I'm sorry, I can't comply with the order. And so impossibility is a defense to a contempt action. And so Anderson's attorneys go into court and say, hey, it's impossible. They've asked the trustee. What made this work here is they didn't have the power to replace the trustee. And so if they did have the power, the judge could order them, I'm ordering you to make yourself the trustee, and then I'm ordering you as the trustee to take the money out. And so how this worked here is that Anderson's attorneys went in and say it's impossible. They can't change the trustee and nothing they can do. They can sit here for the rest of their lives, but the money is never going to appear. So the judge says, yes, I still hate you, but you do get out of jail. So the moral of this story is if it can work for the bad guys, it can also work for us. And so this is why we have set up this three-pronged structure here of even if the judge has jurisdiction over you, they don't have jurisdiction over trustees 2 or 3. And by having, you can't trade out number 2 unless number 3 consents. And so you don't have the power. You can tell trust consultant, I want you to switch out distribution trustee to me so I can distribute the assets. And trustee says no. So we build within the structure all of the safeguards that are there. It seems inordinately complex to some people, but it's necessary to provide the asset protection. The bottom line is, during John and Mary's life as investment trustees, they buy, sell, trade, do whatever they want to, put money in, take it out, and they just live their lives as if everything were good. So that's a little background. Actually, there's more than a little background on the structure of these trusts. Now, for a lot of people, what you have, your most valuable asset is your home or a retirement plan or something. So we're going to talk a little bit about homestead exemptions. That protects your primary residence. So here's some different statutes here in the West talking about the different exemptions. A lot of people, the issue here, again, the worst, unfortunately, happens to be Utah at 42 a pop of equity, and people that have a lot of equity in their home. This is the way to protect it. In the last lecture we talked about LLCs are good for rental properties and businesses and other assets. LLC cannot protect your home. I won't go into all the reasons now, other than it won't work. So LLC is not the answer. The answer is you can set up an asset protection trust. You can deed your home in there, and that one will work. Okay, so let's talk about what assets can be held. So John and Mary Jones have the Jones Asset Protection Trust. They put their house in there. Really should have a 3-car garage, this house that size, but apparently they didn't. So there's their house. They put it in. Again, they create the trust. The same day they create the trust, they deed their house in. And then, again, they got to wait 2 years. After 2 years, something happens. Nobody can get the house. So it's a way to essentially supersize your homestead exemption. So if you're in Utah and you're married and you have $84,000 worth of, it protects $84,000 of equity, and you've got more than that, then that can be a problem. So that's the best way, the most effective way to protect your house. And so, again, if it's over that amount. Okay, so one of the things is nobody can lien. So they get sued, nobody can lien the house. That's good. It preserves all of the tax benefits. So again, we're going to set this up as a grantor trust. And so one of the provisions of the grantor trust is the IRS treats it as if the trust were invisible. So IRS says, yes, so it isn't a trust for state law purposes, for asset protection for creditor. It is a separate independent entity, different than you. Taxes, on the other side, IRS says, you own it, you control it, you're taxable on it. We don't care what you do. We're not going to let you save money, taxes, by doing this. And so as a grantor trust, again, basically a pass-through or disregarded entity, any of your deductions you still get even though it's in the trust. So if you have a mortgage and you pay interest, that's deductible. Property taxes, etc. You also, one of the nice things is it's treated, the IRS says, no, we're treating this as your trust, so you still have your $250,000 per person capital gain exclusion on a home you've lived in 2 out of the last 5 years. So they can still sell the house. So if they've lived in there over 2 years and the house has been there, they say, we want to upsize, or we're going to downsize, or we're going to retire and get a condo, whatever we're going to do. So John and Mary, as trustees of their trust, they can sell the house whenever they want. So the house goes to the buyer. The money comes into the trust. John and Mary don't own it. They're not the sellers, so the money doesn't go to them. The trust owns it. The trust is selling it. So house goes out, money comes in. Again, the holding period applies on the new money that comes in. That's not treated as a new contribution. It relates back to the time that the house went in, however many years ago that was. Then they want to buy another house. Great. Money goes out. Trust, new house comes in, condo, whatever it is. And so that new asset that goes in, again, has tax on the same holding period as the original asset. So So the bottom line is you create the trust. This is basically, it's a one and done. Create the trust, put the house in there, put the other assets in there, forget about it. After 2 years, you're good to go. So what are some other assets? Let's talk about LLCs, limited partnerships. So here's an example. Let's say they have a rental property. Law 101 says anytime you have a rental property, you want to hold that in a LLC. Limited partnership, that's a nice tool to protect liquid assets. It could be another LLC held within, the other LLC, but just to mix and match, we're just going to say it's a limited partnership. So again, what's going to happen is they have a rental property or a business or something. Whatever activity they have that's in the LLC, they're not going to want to store money there because by definition, it's at risk. And so what they're going to do is take the money out as soon as they have any net profits, and it comes out of the LLC into the limited partnership or other entity. The nice thing again about LLCs, limited partnerships, are the asset protection accrues immediately. So this can also be used as protecting assets during the initial 2-year exclusion period. So if they have some assets, finances, other things that they want to protect, they can use the limited partnership or LLC. The nice thing about those is the asset protection begins day one. So I set up the entity, I put the money in, in a car wreck the next day, I get sued the day after. It works because it's in this entity. So the trust doesn't provide the barrier during the initial 2 years, but the limited partnership or LLC does. Here's another thing. So in our prior lecture, we had talked about charging orders. That's the remedy of a creditor about trying to get your stuff. And so what happens here, just briefly, is say you have an LLC and I have some assets in there. Creditor can lien what you own, which is not the property itself, but the ownership of the LLC. And by doing that, what it means is if you ever make a distribution, they get it. Okay, so that is one of the disadvantages of an LLC, for example, is it'll keep people out, but it also prevents you from taking money out. Okay, so a little bit of a restriction. Contrast the LLC with a trust, on the other hand. There is no charging order remedy on a distribution from a trust. So again, they sell the house, they're going to downsize, they have extra money there, they can take that out. Even if there is an existing judgment against them, the creditor cannot attach the distribution from the trust, whereas they can from one of the other entities. So again, there's no charging order remedy after it's been seasoned for 2 years. The only thing that it doesn't help with, the trust that is say John or Mary are high income earners and they're earning it faster than they're spending it. So they have an extra $50,000 a year of income, and so they put that money, $50,000 a year, into the trust. With a 2-year look-back period, you've got, they're always $100,000 exposed at any given time. So for the high-income earners, you can set up the entity, put the money into the entity. The trust won't protect it for the first 2 years, but the entity will protect it from day one. So using a limited partnership or LLC is a nice way to bridge the gap. Okay, what assets can be held? So we have the home in there. We have, again, rental property, investments. What about some people may have an S corporation? Now, one of the rules of an S corporation is you have to have a proper shareholder, the owner. So humans work, a living trust works. What we do in our trust, we also create the asset protection trusts as a qualified subchapter S trust. So somebody can hold stock in their S corporation, in their trust, and it doesn't terminate the S election. Whereas if they put it into another entity, an LLC or FLP, that is not a permissible S corporation shareholder, and it would terminate the S election. So you can protect your corporation within this trust. You can protect your home within this trust, and it doesn't mess up anything. Okay, assets you should not hold into the trust. Vehicles, why is that? Well, pretty obvious. That could be a source of liability. So you don't want to taint any of the assets that you have in there by holding an asset that could cause liability, like a vehicle. And so anything else that could be a source of liability. Here's another question. Does your asset protection trust work for estate planning? And the answer is yes, it certainly can. You can include within your asset protection trust whatever you would have put in your living trust. Does it replace your living trust? And the answer is no, it doesn't need to. So let's do this. So let's say you already have a family trust and you have certain assets in there. Again, family trust, zero asset protection. You say, I'm thinking I would like this. I'm going to set up an asset protection trust. And so you create the trust, you take the house out of the living trust, family trust, put it into the asset protection trust, you put your financial assets, other things there. So now I've got that as a protected box. Things that are not protected are vehicles. Another issue there is for a professional entity, a professional LLC or professional corporation. For a doctor, attorney, accountant, actually realtors are considered, so whatever, if you have a regulated engineer, whatever profession, you have your own entity, state law doesn't permit you to put that into an asset protection trust. You can't have it in a family trust. So what you say is you create the asset protection trust, put the assets there, and you say, whenever I'm gone, it goes to my wife. Whenever she's gone, whenever we're both gone, it's just going to be distributed pursuant to what we have in the family trust, which again is real easy because that's a revocable trust. As you change your mind over time, you can amend the family trust. Now, for those who don't already have a family trust set up and want an asset protection trust, well, by all means, it can do double duty. It can protect your assets during your life, and it can also act as your will substitute. As an irrevocable trust, we put in back doors there that say that you can still, by subsequent document, change what you had within your trust, and one of the kids is rotten, need to disinherit, or somebody needs more, and whatever you're going to do, or, those kids drive me crazy, I'm just going to send them to the grandkids, whatever it's going to be. You have the ability to make those changes within your asset protection trust. Okay, and then the family trust or asset protection trust, if you're doing that from day one, then it can go to the kids, grandkids, other beneficiaries. So basically it all works together. If you have a family trust, you don't have to scrap it by setting up a new one. One of the questions I get a lot of time is, can you amend my family trust to turn it into an asset protection trust? And the answer is no, you can't. It's completely different statutes, but you don't have to throw it away. It's still useful. You just create this something else to hold your assets. So basically, you can create a trust. You're the trustee. You're the beneficiary. After it's been held for 2 years, nobody can get in there. So the kicker here, some people actually do have friends or relatives or somebody they would trust that live within Nevada, that they can use that as a jurisdiction. That's fine. I happen to know of a law firm that can do that, and one of the lower things, $250 a year is the current. I don't know what will happen in the future, but kind of the same as a registered agent, just a minimal fee to be a placeholder, that you can overcome that barrier easily. Again, after 2 years, after you set up the trust, put the assets in, after 2 years, you can do whatever you want to. I tell my clients you can rob 7-Elevens or banks or shoot people. I don't recommend, but even if you do whatever bad, nefarious, rotten things you're going to do in the future, it really makes no difference. You may be in prison for the rest of your life, but nobody can touch your assets. So again, Nevada's ranked top in the nation. South Dakota is number 2. They kind of go back and forth. Both of them are good jurisdictions. Under South Dakota law, you don't have any rule against perpetuities. It can last, forever. Nevada statutes, you can't have the trust last more than 365 years. My prediction is we'll be well into the millennium, and who cares? All right. Again, you don't have to be a Nevada resident if you have a friendly person that you can get to do that. So, in conclusion, Judge Learned Hand. There are two systems of taxation in our country, one for the informed, one for the uninformed. Everybody nods, yes, I believe that. That is true. The next question is, so which is the, who's going to pay less taxes? Well, obviously the person that has the greater knowledge. Knowledge is power. You think of that learned hand, that actually was his given name. And if your parents named you that, they probably wanted you to aspire to be a judge. And anyway, it worked out in his case. So for me, same thing. Two systems of asset protection in the country, one for the informed, one for the uninformed. Conclusion, things you don't want to pay bottom dollar for. Parachutes, no, you don't want the, it's expired special, we're going to get that. Scuba equipment, no, you want to be able to breathe if you're underwater. The other thing is, your documents. Why do you not, if you're going to use them, you need to get the right stuff. You got to make sure it works. There's huge stakes, huge tragic consequences if it doesn't work. And once you learn they're defective, it's too late. So it makes a difference who you use. Don't cut corners, and it may end up costing you more than you think about. So anyway, I hope this information has been helpful to you. Hope you've learned something. A lot of people, I've found that very few people even know that this is an option, that even know that these things exist. Actually, they do exist. They're very powerful. They're user-friendly. You can set it up, and hopefully you can sleep at night. And again, you just want to, whoever you use, whatever attorney, you want to make sure that he or she knows what they're doing so that you can get it set up correctly and it's going to work for you. So thank you for listening. Hope you learned something and wish you all well.